Welcome.
Do my best.
Hope we didn't scare you off.
No, not at all. The,
Did you want to reserve any time for
oh,
rebuttal?
yes, 2 minutes. Thank you, Your Honor. This case really, I think, comes down to the zone of danger argument in the reckless endangerment charge and subsequent conviction. There was a charge of evading that was not allowed to go back to the jury due to the judge's determination that there was insufficient evidence. Those two things I feel are linked, so I'm going to talk about them not together, but I think it has to be mentioned in that the basis for the officer's attention was that when he was driving by and he looked in his rearview mirror and saw two motorcycles pull out of Baker's Bridge, it's a street, and that he, based upon his observations through a rearview mirror, he was able to not only determine the speed, but that, that the proximity of where they were in relation to where he was. I find that odd, but he did, and he testified that he has had some training in that, so we'll take him at his word. The problem for the state is that Officer Mulligan did not make visual contact with Mr. Price again after he turned his blue lights on, spun his cruiser around. He never made contact with Mr. Price again until he pulled him over totally away from where he initially observed them pull out of the area. Also, when he testified, I asked him about the conditions, and he said that it's a normally heavily traveled road, but he didn't state the conditions that I remember on that particular day, and I think that's important because I'm going to use the state's case, and they use the Cross case, and the Cross court really talked about what the zone of danger, and they were very specific about it in that there has to be an imminent danger, death, or serious bodily injury, and that imminent, a person must be placed in reasonable probability, and that danger is more than a mere possibility. Here, and I know in my brief I put that they didn't call any witnesses, and I agree with the state that they're not required to call a separate witness. What I meant by that is I felt Officer Mulligan's testimony was insufficient on its own, and that unless they called another witness, I felt that the testimony was insufficient to establish that zone of danger. So I do agree that they didn't need to call the witness, but I felt like there was insufficient evidence that was provided by Officer Mulligan for the jury to find that he was guilty of that. They've said that the zone of danger is defined the area which reasonable probability exists that the defendant's conduct would place others in imminent danger of serious bodily injury, and that there must be others present in that area. Again, I don't remember Officer Mulligan ever testifying as to what the conditions were that day. He just said what they were normally. And so when...
But wasn't there some testimony that there was limited visibility on the road?
Yes, so the way it was described, as I recall, is that the street goes up on a rise. So where they were, as the direction that the motorcycles were traveling, it went up to like an egress, and then so it would have been out of sight by the time his cruiser turned around. And again, he never made visual contact again until he pulled him over in a completely different area.
But a road with limited visibility is, with someone going that fast, is that not?
I think, as I recall, the limited visibility that was described by him was due to the conditions of the road, not necessarily that Mr. Price was traveling at a rate of speed that prevented him from maintaining visual contact. It could have been, Your Honor. I just don't remember that being specifically testified to. As also in the Cross case, they were very specific. There was vehicles that they were being passed, and they did so in the road. 45-mile-an-hour posted speed limit. I know Officer Mulligan testified. I think it was 40 miles an hour. So obviously, the speeding was well over the speed limit based upon his observation. Also, in that case, there was two other drivers that were identified as being that they were present and that they had to make, I believe it was evasive movements. Here, we didn't have any of that. There was just no testimony that there was a sufficient zone of danger that other cars, other motorists, pedestrians, anything like that were affected by the speed of Mr. Price alone. Moving on, I also argued that Lieutenant Springer is being allowed to testify. I was kind of moved by the state's argument, to be honest with you, as I read his brief. Gotta give it to them if they're right. My analysis of that was more on a more prejudicial than probative. I thought that his testimony had zero probative value, and I thought if he was allowed to testify, the prejudice is if it's outweighing it, then this much is an outweighing. So that was my argument as far as Lieutenant Springer being allowed to testify.
But what is the prejudice?
Well, because he was really testifying about another motorist, and
He was, but how is that prejudicial?
My thought was that his observations of the other motorists would be imbued into my client, in that they were being basically chased together, and that was not the case. That there was no evidence, at least, that these motorcycles were together.
But was that what I haven't dug into the record. I mean, is that what the testimony is? Or was the testimony clear that he was talking solely about the other vehicle?
That Lieutenant Springer was talking solely about the other colored motorcycle.
So again, question is relevancy, but how is it prejudicial?
I think that's why I probably agreed some with the state's argument, Your Honor.
Okay.
Yeah. And then lastly, as far as argued that the sentencing, that Mr. Price hadn't had a conviction in some years. This was a nonviolent offense. The evading had been dismissed, and thought that I just don't think that enough analysis, enough thought was given before Mr. Price was sentenced to jail. That there wasn't, it was just, this is what we need to do to deter this conduct, and therefore, because of his record, he should go to jail.
And it was 6 months to serve.
Yes, Your Honor.
The balance on
Yes.
probation. But didn't the trial court talk about also the circumstances? I felt like there was something in there about how dangerous this was, or how fatal it could have been, but it certainly was dangerous. I mean, if you talk about the circumstances of the offense and the prior criminal history,
He did.
and depreciation, isn't that enough?
You could make the argument, Your Honor.
Okay.
And I think, what we're looking at is, especially when the judge sentences within the statutory range that, and we're looking at how we assess his sentencing, we're not supposed to be overturning the judge if, there's a factual basis for his findings. In other words, we may not, let's say we don't agree with him, but as long as there's facts to back it up, and he gives adequate reasons of why he's doing this, then he should be upheld. What did he get wrong?
Well, I thought that Mr. Price's, in light of the greater charge being dismissed, and that, in fact, 2 charges were dismissed at the trial, there was also
Which the court did itself.
It did. And I was very happy about that. So I just thought that the analysis on deciding to give Mr. Price 6 months in jail was harsh, I guess, considering that I understand it was the felony. I argued that it should go back to the jury as a misdemeanor. That was not embraced. So that was my analysis.
But his reasons he gave was because the defendant had a prior criminal history.
He did.
Okay. And because he was afraid to do otherwise would unduly depreciate the seriousness of the offense that he believed, based on the facts, was a serious offense and needed to have, I guess, a message sent or whatever it is. Those are which are valid considerations for the court. So, again, what did he depart from? That you say, other than you think it was harsh, what did he depart from?
I think I would probably concede the issue, Your Honor. I do. Because, you're right. As we go through it and we say he was convicted of a felony, he had a record, so was jail completely, unwarranted?
Well,
Maybe
she
not.
said no. Yeah. Okay.
there's any more questions. All right.
All right, you still have the remaining time for rebuttal. General Ball?
Good afternoon, Your Honors. May it please the court. Ben Ball on behalf of the state. Looking back at my brief in preparation for this, I realized I did not spend a lot of time on zone of danger. I did not read that as sort of the defendant's primary argument, but I'm happy to talk about zone of danger.
Let's talk, because he mentions that there's really no evidence of who or how many people are on there. Now, I think your argument is correct, is you don't have to bring these people in, but you got to establish that there were people that were in the zone of danger.
And my first answer to that would be we have a second motorcycle who he is traveling side by side with when the officer first sees him. And I know I didn't address that much in the brief. I kind of did it a little more perfunctorily. But we have a second motorcycle. And I think that's important. I mean, and I know this court's probably aware of the drag racing cases that would be sort of similar. Just because he's engaged in the same activity that the defendant is doesn't excuse him from the zone of danger.
But they were separated, though, during the chase.
During the chase they were. When he first observed them, they were both exceeding the speed limit, heading up to this blind turn. They were side by side, and that alone establishes a zone of danger. But
well, were there other cars? The question I have is, based on the first officer, Mulligan, or whatever his name was, he turns around, but is there any establishment of what other than he says what the traffic normally is, about what it was like at this particular point in time?
So early on, we have some testimony from Officer Mulligan that I have to be upfront with this court is a little on the ambiguous side, but of course the jury's verdict resolves any ambiguity in favor of the state, where he's asked how he came to the determination of the approximate speed, which I believe he put it somewhere above 100 miles an hour in a 45-mile-an-hour zone. And he says something to the effect of, when you are observing a vehicle and there are other vehicles and you know their speed, and that vehicle passes them, that vehicle must be going faster. Now, I will allow that one alternative reading of this is that he meant his vehicle.
Yeah, because there's no proof of another vehicle, is there?
But it's a little ambiguous as to exactly what he means, and I would say the jury's verdict resolves that in favor of the state. He does not testify outside of the second motorcycle about a specific vehicle that he says, but he says something to the effect later of they're asked about this stretch of road and its busyness, and he says at this time of day, 99.5% of the time, this is one of the busiest places, essentially. And I think when we take those two things together, and then we add in the fact that we definitely have a second motorcycle, there's a zone of danger here, and that's well established, and I think that the sufficiency standard resolves all that in favor of the state here. As far as whether there was danger, I mean, I think that we have someone on this motorcycle going well over, almost 50 miles, more than 50 miles an hour over the speed limit. And the officer describes them ascending this hill, which is, he says, about a half-mile distance in mere seconds, and disappearing into what, and I don't know if he uses the term blind turn, but a limited visibility turn where you can't really see what's coming. And so, given those facts, the evidence is well sufficient to support this conviction. I won't linger on the other two issues unless there are questions, except just to say, in addition to the testimony from Lieutenant Springer being relevant to corroborate what Officer Mulligan had said about chasing the second bike, it also helps establish the presence of the second bike. It is definitely probative, and there's nothing prejudicial about it. Finally, with sentencing, just note for the 6 months of his 2-year sentence that the defendant was required to serve, the trial court, as Your Honors noted, did not rely just on the deterrence. It also did not rely just on the seriousness of the offense. There were these two things combined, and there was also his criminal history, which, for evaluating whether this is a good candidate for an alternative sentence, this criminal history included a failed attempt at judicial perversion, and I think that's especially probative here of whether, as far as his criminal history, whether he should get another shot at probation. So, if there are no other questions, ask this court to affirm the judgment of the trial court. Thank you, Your Honors.
Is it Riviere, did I pronounce that correctly? Okay, thank you.
The formula that Officer Mulligan employed was just that. It wasn't a real-time, real-life, this is my observation. He just said it's what he, everything was what he normally did. It was normal traffic, but he didn't say what they were. And also, when those two motorcycles pulled out, it was a general statement. He's like, I saw the motorcycles, they pulled out. Never said one after another, never said handlebar to handlebar, anything like that. Sometimes I thank God about the questions I didn't ask, because it became more ambiguous as I looked at it, because he never established anything about that. He never even said, never gave us timing, never gave us distance, anything of those two motorcycles. So we're just to assume what may have been. And I understand the general's argument that the jury found that, but the defendant's argument is it shouldn't have went back in the first place. So I don't know that that's a moving argument, but I understand it as well. Also that he said that I'm not sure he said 95%, I don't remember that, but I'll take it. But again, could have been that 5%. He just never said, and we don't know. And I think we need to know, because the court has been very specific about identifying what the zone of danger is. They didn't say a general totality of the circumstances. They've been pretty specific about it. Were there cars having to get out of the way? Were there people really put in danger? Because speed is not enough. It says that. Speed is not enough. It's not good, and I get it, but it's not enough to establish zone of danger and therefore felony reckless driving. I ask that you rule in favor of the defendant. Thank you.
All right, thank you both. And we will move to our last case, please, if you'll call the case.